So welcome everyone to this special edition of the Health Check podcast. HSJ is today joined by one of our Wilmington umbrella companies, Bond Solon. Now, for those of you who haven't heard of that company, they are a legal skills and safeguarding company, and basically they help train health and care professionals who do not necessarily have a legal background in trying to understand the legal complexities around the duties that CCGs providers and individuals have to apply to when it comes to health and social care. This particular session is going to be looking at the Coronavirus Act 2020. It was introduced into Parliament on the 19th of March, so it was almost a whole month away. And it was, I think, people seem to agree that it was quite a hasty piece of legislation put together quite quickly to try and react to the speed at which the pandemic is travelling around the country. And I think as a result of that, some people are struggling to understand their duties under it and also how it fits into other parts of legal acts, such as the Care Act. So I think this is a great opportunity for our two guest trainees to help us come to terms with some of the issues behind that. So first, let me introduce Francesca Berfield. She's a barrister and also our expert in children's health and social care and on issues such as capacity and consent. And we're joined by Matt Duddles too, who's a solicitor, and he's our mental health expert. Although obviously they
Good
do
afternoon, everybody.
All aspects. So I think I'll kick this conversation off, Francesca and Max, by asking a very basic question. What is the Coronavirus Act, and what are the basic principles it puts down in law that people should be abiding by?
Well, it is basically, I think you summed it up quite nicely at the beginning, Sharon. It is a very hastily enacted piece of legislation which seeks, in effect, to protect the public safety from the effects of the Coronavirus Act, whilst still, and I think this bit is important, whilst still maintaining the human rights, the fundamental human rights of the individual. And the Act itself isn't particularly remarkable. It basically brings in a whole load of schedules, and it's what's in the schedules that's the important bit. And these schedules can be switched on and off individually. And each schedule deals with something specific. You mentioned the Care Act. There's a schedule that deals with that. There's a schedule that deals with how to use the police in order to enforce things like quarantine. There's a schedule that deals with the Mental Health Act and so on. And these schedules can be switched on and off individually by a series of regulations. And along with these regulations coming into force, we also get guidance which is issued as to how best those regulations can be implemented. As things stand at the minute, some schedules have been enacted, other schedules have not. Some guidance is out, some is not. So we're in quite an interesting situation legally, to put it mildly.
So Max, may I ask, these schedules that you talk about, which ones are to our listeners who are health and social care, which ones are most relevant to them?
Well,
so
if you're talking
quarantine one we all know about, because we've heard police, asking people to move on, dousing picnics with water filled in their helmets, etc. But which ones are specific to health and social care that they should be focusing on?
On that score, maybe not entirely strictly speaking legal. That having been said, Schedule 12 is the one that applies to health and social care, and that is in force. That's there. It basically came into force on the 31st of March, with very snappily entitled the Coronavirus Act 2020 Commencement Number 2 Regulations 2020. But along with that commencement regulation, there was one piece of guidance in particular, which was entitled the Care Act Easements Guidance for Local Authorities. And it's that guidance that is really, really important.
So Francesca, is there any chance you could talk us through what some of that guidance says that is relevant to CCGs providers and obviously those of our colleagues in social care?
Well, in relation to the easements, as I said, in other discussions, it's about really these stepping stones, and therefore really thinking that all of that is lined up in relation to potential watering down of certain provisions of the Care Act, by way of example, allowing us to be thinking about duties being restricted down to powers. And therefore also thinking, though, that it doesn't mean that somebody, let's say within adult social care, decides today is the day to do it, so I'm going to bring around those changes unilaterally. They've got to be very much awaiting the appropriate decision from, by way of example, the Director of Adult Social Care. So it doesn't necessarily equal that while they sit there, they can be turned on and off by the individual. It's very much thinking the actual public authority and those very much at the top being responsible for that. But also you've got to add to that the current test, which is quite clear within the provisions, that the Director of Adult Social Care can only really look to apply and direct that these easements are applied if they're able to satisfy themselves locally that they meet the appropriate test. And that very much being, in summary, the workforce is significantly depleted. The demand on social care has increased to such a degree that it is no longer reasonably practicable to comply with the provisions of the Care Act as it currently stands. So therefore, it's not just today is Thursday and off we go. It's that you have to actually meet all of that criteria.
So when we come to talking about easements, is it then decided on a local authority by local authority level? It's not decided at a national level?
Yeah, well, the power to bring in these easements is there. It is within the Care Act on the Director of Adult Social Care within that local authority to look at what's going on in their area, to assess what the demand is, what the workforce is like, what resources they've got, in other words, and then really in conjunction with their colleagues and other relevant organisations within that area to make that decision. And really the acid test for that particular decision is whether or not, in continuing with business as usual, it would in fact be likely to result in urgent or acute needs not being met, potentially risking life, to quote the guidance exactly.
So in practice, does this mean that, from what I understand, this means that some people who were having their needs met may now only have those needs met if it would be a breach of their human rights to not do that? So effectively the bar is being raised. Is that correct in my understanding as a non-lawyer?
In your understanding as a non-lawyer, in certain cases, and I want to put a load of caveats in there, but in certain cases, Sharon, yes, but not in all cases by any stretch of the imagination.
So when you say not in all cases, how does it apply differently? Is it done on an individual basis or is it done on capacity?
Well, what would happen with the Director of Adult, sorry to keep going back to the Director of Adult Social Care, but they are very important in this particular scenario. What I have seen of these enactments, what happens is the Director of Adult Social Care consults with colleagues and then issues their own guidance for care staff and for their social workers as to what should be being done and what shouldn't be being done. So, for example, in one particular area, they may say, OK, we're going to use the easement which closes day centres, or we're going to use the easement which says we're not going to be doing financial assessments for care until afterwards. And then there will be some guidance to social workers which might say, but in making it clear that we're not going to be doing a financial assessment, you need to speak to the person, you need to speak to their personal representatives and make it clear that there will be a financial assessment. It's not just going to happen at the minute, so that they're not suddenly stung or taken by surprise at the end, you see. So
I think also add to that, though, that it is that there is this ability to switch it on and off. So as soon as, let's say, going back to our Director of Adult Social Care, if they're of the view that actually circumstances have changed and let's say the pandemic is moving away and or we're suddenly back to our appropriate levels of staffing or resources are there in a different way, then they're not allowed to just trigger and let it sit there indefinitely. There has to be that continual review. So they're emergency provisions to only be used in those very extreme circumstances. So yes, they've got to prioritise to some degree who is the most vulnerable in that list, but equally they cannot afford to take their eye off all of the other adults that equally have needs for care and support.
I think that's reassuring on many levels. Can I ask, there are some concerns coming in from clinical commission groups, CCGs, and also some social care bodies that they may at some point, when the pandemic or the crisis has somewhat abated, they may at some point be challenged on some of the decisions they've made during that pandemic. Have you got any advice for people having to make these decisions quite quickly as to how they can maybe protect themselves against future challenges as to why those decisions were being made?
I think what I'd say in reply to that is I would hope it would be there anyway as standard practice, but they've got to be very alert to good, adequate record keeping in order for them to hopefully be able to provide any court, tribunal, complaints process with defendable decision making. To me, what needs to sit behind that is good and adequate record keeping, but also within that record keeping, not just the facts of the day, but also ultimately what evidence base, what information was available that they considered, who did they consult with, be it the individual person, their family, other professionals, what was the risk assessment they arrived at and on what foundation, and then from that also allowing themselves to move then to consider what are all the realistic options today. I think also it's key, particularly during the pandemic, that there is an ability to review and revisit every risk assessment and every decision. And if the audit trail is then there to support it, I think there's going to be a huge number of challenges. There is currently, let's say, family courts as well as the Court of Protection as well as mental health tribunals. But I think if and when we all move through this, there will be not only a public inquiry, but I anticipate judicial review, civil actions in relation to negligence claims, breach of human rights. I think even criminal proceedings, either by, let's say, CQC under Regulation 13 and or criminal prosecutions by the CPS, willful neglect and potential gross negligence manslaughter. Professional bodies, I think, will also be holding some to account. So all the more reason that I think it's all about not only defendable decision making, but the appropriate audit trail behind it to enable others to understand what was actually showing itself at the time, and really allowing them to think about the full context that needs to be in that audit trail.
Yeah, I think, sorry to interrupt, Sharon, but I think it's also perhaps important to say this, that there will be legal challenges, there inevitably will be. We are living in incredibly unusual times and people are under a great deal of pressure to make some very important decisions very quickly, and that's not fair on anybody. That having been said, as well as doing the record keeping and having that audit trail, being aware of what the law is now is absolutely vital. If you act in accordance with what the law is now, you are able, if you have the correct records, to defend your decision. You can actually chuck something at your lawyer and they've got something to get their teeth into and put a defence together. But you've got to know what the law is, and you've got to keep those records, and you've got to consult with the people you've got to consult with. And that's, I think, the best bit of advice we can probably give everybody at this particular point.
We've had some interesting questions coming in from that. Actually, may well come back to what you were about to say there, Francesca. Some interesting questions come in about from Bond Solon clients, some asking a list of ways in which the public authorities can be challenged, and another one, quite an interesting question: what happens if you are part of a significantly divided group in which a decision is made but you don't agree personally with that decision?
I think that's inevitable, and I think actually that would probably constitute more readily defendable decision making. I would be very surprised that all professionals, and let's suggest family members and all of those involved in a decision making process, should all agree entirely with one another. And I think it's absolutely right and proper that if there are a few or some that aren't in total agreement, that still has to be part of the decision-making process. And I think that's right, and that should be encouraged. Ultimately, though, a decision has to be made, and what I really wouldn't want to encourage is that it just goes round and round and round and nobody actually takes the ownership and makes the decision. But I think inevitably, particularly with the pressures that people are under at the moment and the fast moving spread in relation to the pandemic and what's happening on the front line, I think there will be be occasions where it's very much felt, well, I didn't agree with that, but that seems to be the decision that's carried. Again, I'd say, falling back on the comprehensive audit trail, we will quite often see that even in our classic challenges before any court or tribunal.
Oh, I see that all the time in my practice now. That there's no reason why it should change. It is important that all people's views are taken into account, but inevitably, in a lot of cases, somebody is going to have the majority, as it were, go against them, and there's no harm in that. It is, as Fran says, about defendable decisions.
And one from me, really, with CCGs in the time before COVID, they obviously had a lot of legal duties to be as transparent as possible, to hold meetings in public, and to also involve lay members and non-executive directors in their decision making. How much of that still needs to happen, given the time constraints and the speed at which decisions are being made? I'm specifically going to the issue of public maybe attending and involving consultation around that as well.
Ideally, all of it. The nearest, I appreciate the difficulties, but the nearest one can get to normality, the better. Every effort should be made to carry out, especially those public consultations, effectively. And going back to the recording, every record should be kept of those efforts. We are talking at the moment to each other across Microsoft Teams. Other video conferencing software is available, in particular, for example, Zoom. Zoom, we know, because we've been in on these meetings, can host over 700 people at any given time. So if, for example, a CCG was to carry out a public consultation about an important thing, and that required a meeting, holding a meeting over something like Zoom would be perfectly feasible, and we would expect to see that be carried out. Not, for example, the excuse, when it was the coronavirus, we couldn't consult with anybody in a big meeting hall. It's about finding creative solutions. And
what about the time of that should be allowed to advertise these meetings in advance? So, for example, we are hearing that most IVF practices have been stopped because of COVID. Normally, you would run a consultation over a period of weeks, if not months. How long now do you think CCG should be kind of advertising these in advance to make sure people know that these consultations are happening? And how long can the consultation stay open for? Because obviously we're 4 weeks in from the less than 4 weeks in from the Coronavirus Act being introduced to Parliament, and things have dramatically changed over that period of time very quickly.
Yeah, it has, and the timeframes that you discussed, that you outline, are clearly not feasible here. As much time as possible, bearing in mind the decision, is the best thing that I can say there. If that is a day, it's a day. But what you do is you pump that out on social media and through emails and all the rest of it to make as many people aware as possible. If you pump it out over Facebook, for example, there's a lot of towns, a lot of villages that have their own Facebook page. Get it on the Facebook page so that people are aware that consultation needs to happen. And if you're able to demonstrate that you've done that sort of thing, later on nobody's going to be able to turn around and say, well, this was a decision which wasn't made properly because there wasn't proper consultation.
I think you've got to be a bit more creative, and it's quite interesting. If I can just use a few other examples, how the courts, how child protection case conferences are still supposed to be, in quotation marks, business as usual, but it's moving it to other ways to still get that discussion and that hearing going and that determination arrived at. So I think it's about, okay, we may have to change and alter what we've all known has always been the current practice, but we've still got to use our best endeavours to arrive at appropriate decision making and allow people to have a voice within that. But I don't think that, let's say, professionals will be unduly criticised if we've had to adapt in a way to still allow there to be a fair trial and still allow all of those voices to be heard.
So can we move on to asking about Hancock last night issued a new guidance for adult social care, in my mind, very late to the day. But in that, he did say now that people should have a right to say goodbye to people who are dying, which we know has been issues in the past. I mean, absolutely distressing issues where a 13-year-old boy died with no relatives with him at all. And obviously that seems to go against some of the case law that we've seen that's come in since the pandemic. I'm going to pass this over to you before I start quoting case law incorrectly, but I believe there was something there about Surrey Council that's come through, and that outcome now seems to be at odds now with Hancock's guidance. So can we talk through that a little bit?
We can. Do you want to take that one, Fran, or shall I?
No, if you want to, Max.
Okay, well, the case law is BP against Surrey County Council and another. It's a 2020 case law, of course, and the actual citation is England and Wales Court of Protection number 17 EWCOP 17. The judgment in that particular case was basically this, that draconian restrictions on contact can only be justified where all practicable steps are taken to secure the maintenance of such contact as can be achieved. So all practical steps have to be taken, and if having taken those steps, contact was still had to be restricted draconianly, then so be it. But in all other cases, then whatever contact as can be given effect to should be given effect to. In other words, there shouldn't be blanket decisions on restrictions of contact. We do appreciate, certain hospitals, and I'm thinking of Great Ormond Street here, had very real difficulties with staffing to be able to facilitate that contact because of staff being laid low by the coronavirus. But this is a daily thing, so hospitals one day might not be able to allow contact to take place because they haven't got the staff to do it, or they haven't got the PPE to do it, or whatever it is, but on another day they may have. So this is very much a movable feast, and hospitals can't, or anybody else can't, just bring in a blanket restriction for the entirety of the pandemic and expect it to stand up to legal scrutiny. And that was basically the problem with that particular case.
Yeah, and I think also the government rightfully was anxious that it clearly is challengeable. If you're not dealing with it, on each individual patient or individual service user, then immediately to say actually this is a blanket decision to refuse any contact or any visits, that in itself breaches, well, I'm just thinking about it out loud, it's breaching certainly Article 3, Article 5, Article 6, Article 8, Article 14 in relation to human rights. And therefore, because they moved more towards the organisational needs and the fear about public health, they took their eye off the ball in relation to all of the other rights that are equally as important and must be recognised in and around the Coronavirus Act and all of the schedules.
Yeah, Article 2 as well, the right to freedom from inhuman or degrading treatment.
Can I ask as a question from myself, but how does this all fit in with the Equalities Act? Because I know there's a lot of concerns around disability groups, for example. I raised concerns that some of the issues around who may or may not get a ventilator they feel discriminates against them and doesn't recognise what they see as their own quality of life, which other people may not see as a good quality of life, but they want that defended. So how does you talked before, Francesca, about balancing out the decisions made under coronavirus with other acts that are available? How does the Equality Act fit into some of this thinking?
It's still good law and it must be complied with, as must Article 14 under the European Convention of Human Rights in relation to discrimination. United Nations Convention for persons with disability as well. There is no opportunity here for anybody to try and sidestep and or circumvent all of what is good law. The Coronavirus Act and all of what we've just touched on has to sit inside all of that, and therefore it doesn't allow us to have the ability to say, well, we've got this pandemic going on and therefore we're going to literally park all of that, we'll come back to it some old time. It's still there, it's still in force, it's still got to be complied with. And therefore, to me, the sort of groups you've just described actually come to the forefront, even more so in the way that I would be approaching decision making, rather than pushing them some way away or down the ladder in relation to their importance.
And I think one of the things I would like to bring in now is this issue around mental health and the Mental Health Act. How does I was quite confused myself, but the Coronavirus Act does make changes and amendments to that act, but as of yet they've not been officially brought in. Is that correct? Maybe Max, you can explain that.
That's basically. I refer to things Yeah, I refer to it as being switched on.
Yeah, right.
We can go back to the schedules, and this is the point. The schedule that deals with the Mental Health Act has not yet been switched on. It's not yet received any regulations. There has been no guidance issued. So as far as the Mental Health Act today, I'll make it clear, it might be different tomorrow, it might be different next week, but as far as the Mental Health Act today is concerned,
And
it is.
for readers, sorry, for listeners, this has been recorded on the 16th of April.
Absolutely.
So that's when we say today, we mean that date.
Yeah, and about 3:45 as well. I make that clear because the law changes so quickly here. But as far as the Mental Health Act at this point in time is concerned, it is business as usual. Now, here's the interesting thing. When these easements, if these easements are switched on for the Mental Health Act, it is much more nuanced than just, and I suspect one of the things that maybe you've heard, Sharon, is this automatic, if you like, when it's switched on, the need going from 2 registered medical practitioners to certify that somebody is suffering from a mental disorder for admission to hospital down to only 1 of them. No, that it's much more nuanced than that. And taking that as an example, you should only go, even if they are switched on, you should only go down from 2 to 1 if, in the opinion of the AMP, it is not, well, there's a particular form of words, but basically it is not practicable. It is not possible to find 2 registered medical practitioners. And how does the AMP do that unless they actually make enquiries of the medical practitioners of their area to see who is on duty, who isn't, who is around, who is not? And I very much expect that what we're going to find, if the easements are switched on for the Mental Health Act, a similar sort of provision as came in for the Care Act on the guidance, where with the Care Act, we've spoken about this person before, but the Director of Adult Social Care gets to issue guidance. I think we're going to find a similar person in a position of authority within an NHS mental health trust be given that responsibility for the consultation and switching on, issuing their own local guidance. So at the moment, anybody out there who's listening, as things stand at the moment, it is business as usual, and wait for that guidance to come. And that guidance will then tell you what you should and should not be doing.
And for our listeners out there, do we think this is going to be switched on anytime soon? It obviously hasn't for quite a while now. I mean, what would cause it to be, to go live?
Firstly, there is a lot of debate about this in social media, and I've seen very well-known commentators say, "Oh, this should be coming live imminently," and we hear that certain people have written to the Secretary of State to ask him to switch on these easements, but nothing has happened yet. And it's going. Basically, we're going to see these easements switched on country by country.
Yeah.
So if we look at England, the most pressure in relation to the coronavirus, I think, can be found in London as far as NHS is concerned. So when we see the mental health services in London get to the point where they are unable to cope with the demand, either because the demand has gone up, because people have been self-isolating and they've become mentally unwell due to, because of, or as a consequence of that, or because they've got such reduced staffing levels they can't deal with demand, then we're going to see it switched on. At this particular point in time, I do appreciate we are getting closer, but I don't think we're there just yet. I suspect this week everything will continue as normal. Next week, I think that will, and maybe the week after, that will come the crunch, because at that point we're going to see the effect of the peak, or what we think is the peak, on services. And I think it's at that point that we will then get a very good idea as to whether or not those particular easements are ever going to get switched on, or whether they're not necessary.
And how does any of this affect the deprivation of liberty work and acts around that?
Right, Duddles and the MCA, again, I'm sorry to keep repeating this really, but it is business as usual.
Yeah.
There has been guidance issued quite recently. That guidance doesn't say anything new particularly.
Okay.
It does, I think, bring into the forefront certain things that people who are involved in that line of work should be thinking about. And I don't want to get too legalistic, but there's a couple of cases that are mentioned in that guidance. There is the case of Ferreira, which I think is particularly important. And what that case basically said in a nutshell, is where somebody lacks the capacity to make decisions as to their own care for themselves, but that the care, the treatment that they need is treatment that would have been given to anybody anyway. For example, treatment to save somebody's life for COVID-19, which is why Ferreira is mentioned, then it should be given. So you shouldn't be looking for a deprivation of liberty safeguard. You shouldn't be looking for a best interest decision. You just get in there and deliver that treatment. And that's always been the case. But it's just that Ferreira, it's mentioned, the case of Ferreira is mentioned to remind everybody of that. Similarly, where you're talking about treatment that isn't necessary to save life, then the case of Cheshire West is mentioned, and the acid test in that case, which is basically if that treatment amounts to a deprivation of liberty, an intrusion on somebody's liberties, for example, then deprivation of liberty safeguards should be activated. So that should be the referral made as a matter of course. And I would just add this, because I do know that some London boroughs are basically saying, well, we're not going to act on them. You should still make the referrals. It doesn't matter what the London boroughs choose to do. If you've done your job properly, you're not going to be criticised later on. The London boroughs might be, but you won't be.
I mean, I think that's highly challengeable, isn't it? Why they've made that decision, I know not. But I think it is about, isn't it, actually individually and locality to locality. It's actually looking at that appropriately in relation to the right course in law as well as ethically.
Yeah, absolutely.
Guys, I think this has been an absolutely fascinating discussion. I've learned a lot. Thank you so much for making it, for using layperson language and making it easy for people to understand. I'm going to wrap that up here. I do hope we can speak to you again in the future where maybe some of these enactments have been, or schedules have been switched on. It does sound a bit like Christmas tree lights when we say that. And thank you so much for your time. So Francesca, thank you very much, and Max, and we'll leave it there. So thank you very much to everyone that's listened.
You're very welcome.
Thank you very much indeed. I enjoyed the session. Thank you.
Thank you.